good afternoon, good evening, good morning, good whatever it is where you are. I'm Kenn Joyce from Alienated Children First, and you're very welcome along to another in our series of webinars dealing with parental alienation and all matters to do with child welfare. We are child advocates at Alienated Children First. We are gender neutral. We believe all forms of abuse are wrong, particularly, obviously, that of the sadly misunderstood far too often parental alienation. One of the things that we have discovered to cause parental alienation, without a shadow of a doubt, is abduction. And this happens far more than we would like. We have various measures in place internationally to try and prevent it. And now and then we come across an expert in the area. An international barrister is with us tonight for part 2 of her series on abduction, this time from overseas into Ireland. And I would like to welcome Caroline Langley along. Caroline, if you could show us your video, and there she is, and unmute your mic. We're good to go. How are you, Caroline?
I'm very well, thank you, Ken. Thank you for that lovely introduction.
You have you gave us a great presentation last week about the problems of the Hague Convention, how it deals specifically with issues of jurisdiction and not really helping you to get your kids back. You pointed out to us how time specific and how time is so important in getting your kids back should the terrible disaster of abduction occur, in which inevitably, you pointed out, will occur parental alienation. But this evening you're going to tell us about what happens if somebody abducts children into Ireland as opposed to out of.
Yes, and Ken, I'm hoping also to squeeze in a little bit of time to talk about, once a return order is made and one goes to a custody hearing, that at that point, how one brings in to evidence parental alienation issues. So I think it will be of interest to the wider audience.
Absolutely, and you gave us a DIY kit last time as well, whereby we could do a lot of the donkey work on this our own and save the money for when we actually end up before a judge on legal fees and that. So anything at all that we can do ourselves is greatly appreciated. And please tell us anything you'd like about the Hague Convention. And of course, we'll make time for anything else that you care to talk about. Caroline Langley.
Okay, well, thank you very much. I'm just going to share my screen now. And I think that is what that is.
You're an old hand at that at this stage,
Caroline.
Oh,
I know. Let's have a look. Whoops, hang on. I just have to do one more click here. That's the one. All right, hold on to your seats. It's going to be a bumpy ride, but I hope you'll benefit. All right, well, thank you, everyone. And I'm delighted to be back on part 2 of my webinar series. As you may remember, my name's Caroline Langley. I'm a barrister, a mediator, and attorney called to and practicing in 4 jurisdictions, specifically in the areas of child abduction and child abduction appeals and parental alienation. Right, so tonight we are going to be looking at some very specific areas, namely parental alienation and abduction. We're going to be looking at a case, a fictional case, where a child is removed from a Hague Convention country to Ireland, which is the reverse of what we looked at last week. A quick look at a custody hearing after the return order, and when and how to raise issues of parental alienation. Right, so again, just to recap last week, abducting a child from one parent and their home environment is an absolute act of parental alienation. And a child can and does experience Stockholm syndrome within 3 weeks of abduction. And we're all familiar with that term. I think, Ken, you touched on it last week as well. So a child is suddenly removed from its home, its family, its culture, and very often its language. The child is often told that the parent that they have been removed from, and we call that the left behind parent, has deserted them, doesn't love them, or is dead. So the poor child is in a complete state of utter shock and fear. Right, in our fictional case study this evening, we're looking at a family, a man from Ireland, a woman from the States, and 2 children. They'd been living from the States. He came home on holidays and kept the children. So MM against FF, that's mother against father. Mother brings a return petition for the return of the children to the States. Father wants to keep the children in Ireland. The first child is 5 years old and the second child is 8 years old. The minute this happens, the left behind parent or the alienated parent must make notes of everything. Who did you ring? Who did you speak to? What did they say? What official did you speak to? All your text messages to various parties, including the abductor, print them out because eventually they will go into a large evidence pile. So don't leave it until the end. Were you able to speak to your child? When did you speak with your child? Dates and times, for how long? Was that phone call or Skype call cut short? Was there a third party in the room? As much detail as you possibly can, you start building your chronology from the day that your child goes missing. What happens next? So mother in the States will contact the American Central Authority, and over there it's called the OCI, or the Office of Children's Issues, which is a department within the State Department. So mother can file a Hague application for return directly with the Office for Children's Issues or directly with the Irish Central Authority. If she chooses to file with the OCI in the States, they will remit her application to the Irish Central Authority. At that point, it will be turned into a legal document called a petition that will be filed with the Irish High Court. Mother can also, at the same time, file a Hague petition for return directly to the High Court in Ireland, where Hague petitions are heard. There is a specific list called the Hague list. And as you can see there, petitions are in red. That's the legal document. The applications are the lay document. As I mentioned last time, the Hague Convention is a jurisdictional remedy only. So those countries that are colored in pink or purple, 91 countries are signatories to the Hague Convention on Child Abduction. I had hoped during this second webinar, I would be able to touch on the non-Hague countries, but I don't think there's going to be time this evening. So the Hague Convention is simply a set of guidelines to determine which is the proper court to make the custody determination. So already we're looking at a 2-step process: a court to determine which is the proper court, and then the proper court to determine custody. I just want to go over what a jurisdictional remedy means. It is deciding whether the habitual residence for the child is the USA or is Ireland. So because the child has been taken to Ireland, it is the Irish court who decides whether the child should be returned to the States or whether the child will stay in Ireland. I'm just going to go to Article 19 of the Hague Convention. It states that a decision on a return application is not a determination of custody. So if you win, or in this case, if this lady wins her return order and she gets to take her child back to the States, that's all she's got. She hasn't automatically got custody. That's the next step. just to reiterate the point again, a Hague hearing is not a custody hearing. It's a question of where the custody hearing should be held, not who should have custody and why. In a Hague hearing, there are only two questions for the court. Is the child's habitual residence in Ireland, or is the child's habitual residence in the States? The second question is, does the father have a valid defense for wrongly removing the children from the States and retaining them in Ireland? Another point I really want to make clear is that a Hague petition is a civil court. It is not a criminal court. So if there are criminal proceedings brought against the abducting parent, that will be heard in a different court again. So what about the child's best interests? Where do they come into a Hague petition? I had a quick look through the recent case law, and the Irish Supreme Court, that's the you can see the notation there, IESC, in 2019 decided a case called MS against AR. So the Supreme Court is the highest court in the land. And so that's, one can appeal decisions up to the Supreme Court, and then what they say is gospel. At paragraph 55 of this case, I think it was Mrs. Justice Giogan said, Article 19 of the Convention expressly provides that a decision on a return application is not a determination on the merits of any custody dispute. So she's just confirming what I've said in the previous few slides. Now, interestingly, she goes on to say a consideration of the child's best interests under Article 13 does not require a full welfare assessment. So they can consider a child's best interests, but that's really not going to be the determining factor. So just to reiterate this, parental alienation can be raised, will not be a deciding factor in a Hague matter. The factors that comes into play in the custody hearing, which takes place in the court of the child's habitual residence. So the Hague hearing takes place in the High Court in Ireland. If the return order is granted, then mother will take the children back to the States. There will be a hearing in the family court in the United States. If, however, her return order is refused, then the children will stay in Ireland. Mother, of course, has the option of staying in Ireland as well, which is not her home. And then that family will go for a custody hearing to the relevant family court in Ireland. So either way, there will be a custody hearing following the Hague hearing. I just want to look one more time at Article 19 of the Convention. A decision on a return application is not a determination on the merits of any custody dispute. Back to the same case, again, decided in 2019 at paragraph 58. And I think it's very well set out here. The underlying policies of the Convention are that it is in general in the best interests of children that custody disputes be decided by the courts of their habitual residence, and that the abduction of children across borders is harmful to them and should be deterred. So again, this case reiterates that custody disputes are decided in the family courts where the child is habitually resident. Now, Article 13 is known as the defenses. Remember, I said there were two things that the court had to decide. And the second one was whether the abducting father has any defenses for taking the kids from the States to Ireland. So I have paraphrased this in case you're reading along with your Article 13s there. The court is not bound to order the return of the child if the abductor establishes that the left behind parent was not exercising rights of custody at the time of removal, or had consented to the removal, or there is a grave risk that a return to the country here, the States, would expose the child to physical or psychological harm or place the child in an intolerable situation, or the child objects to being returned. In considering the circumstances referred to in Article 13, the Irish court shall take into account information relating to the child's social background. So again, this is very generally worded. In theory, a social background is not a full welfare check, and that social background must only relate to the defenses that are put forward in Article 13. So experts' reports, psychological assessments, etc., must relate to Article 13. And usually those reports are brought in to look at habitual residence, grave risk, and child's objections. And in this case that I'm citing, it was to do with child's objections, and the experts were brought in to assess whether the child was mature enough to be able to give evidence and state coherent reasons why he or she did not wish to return to the States and why he or she wished to remain in Ireland. Of course, the flip side of this is that if the child is undergoing Stockholm syndrome, has only been with the abductor, then of course, as I mentioned last time, they're coached. They're always coached. So that's a difficulty when we get into the child objection areas of Article 13. All right, so let's have a quick review before moving on. The left behind parent, here the mother, must establish that she had custody, that the US is the habitual residence of the child, that she did not give consent, that she brought her petition within a year, and that if the child or children come back to the States, there will be no grave risk to them and they will not be placed in an intolerable situation. And continuing on just the procedure, the indirect route would be for the mother to file her application to the OCI in the States or to the Irish Central Authority. The OCI will remit the application to the Central Authority, who will convert that into a petition and file it with the High Court in Ireland. Additionally, mother can go through the direct route and file a petition herself, whether she's written it by herself or instructed lawyers to do so directly to the High Court. So you can have two petitions going at once. And I think, as Ken asked me last time, it's just whichever one reaches the court first, then you withdraw the second one. So where and when do I raise my parental alienation issues? Well, not at the Hague hearing. You can raise them, but it's not going to be relied upon. So you have your Hague hearing in the High Court. Mother's petition will be filed. Father's defense will be filed. Both parties will offer evidence, and the judge will consider the 5 factors of custody, habitual residence, no consent, filed within a year, and no grave risk. The judge may also consider whether or not there's an objection from the child. The parental alienation issues are raised at the American Family Court if the return order was granted and mother goes back to the States, or at the Irish Family Court if the return order was refused and father stays here with the children. So that is where you fight for probably full custody based on the fact that the children have been alienated from you. But you need to make a very strong case, and this is what I want to look at today. So the family court of the child's habitual residence, whether it's in the States or whether it's in Ireland, this is where we look at custody, the best interests of the child, parental alienation, the voice of the child, various experts' reports, and any allegations of domestic or sexual abuse. Bear in mind that the alienated or the left behind parent presents to the court as angry, afraid, anxious, and agitated. The difficulty with this is that the court, we say the court as though it's an inanimate object. The court is populated with people, namely the judge, who is a human, a person, who take this demeanor on board. It's a problem because the abductor or the alienator presents as cool, calm, charming, and convincing. And this is where we often fall down in the human factor when arguing parental alienation issues. Now, let's take a look at the evidence we should be bringing before the family court to prove parental alienation. And really, if you use this as a guide and you stick to the 5 factors, you can create your own evidence bundle. Was there contact refusal by the child? And if so, when did it start and did it escalate? Was there a previous good relationship? If so, how long was that for? Give some examples of that relationship. Is there an absence of abuse or neglect on the part of the alienated parent? Does the preferred parent or the kidnapping parent engage in alienating behaviors themselves? And are there behavioral signs of alienation in the child? Now, it's that 5th one that I want to take and dig into just a little bit more. There are 8 basic behavioral signs of alienation in the child. And one is the child's campaign of denigration against the target parent. 2 is the frivolous rationalization for the child's criticism of the target parent. 3 is a complete lack of ambivalence or emotional attachment to the target parent. 4 is the independent thinker phenomena. 5 is the reflexive support of alienating parent against target parent. 6 is borrowed scenarios, and that's the one I tend to see most often when a child is using adult terminology or adult scenarios. The other one I'm seeing more often now is the spread of the child's animosity to the target parent's extended family. And finally, the absence of guilt over the exploitation and mistreatment of the target parent. And that is all I have for my presentation this evening. So Ken, I'll just go back to you and see what questions that you have for me.
Well, straight away, Caroline, firstly, is Moon Tora taught to you? You should have been a teacher. That was very clear, even to the likes of me. So thank you very much for it. There were a couple of things that I thought perhaps not everybody might understand. The first was, and I did mention it myself last week, but I wouldn't be qualified to give any kind of definition. Stockholm Syndrome.
Yes.
What is it?
Well, Stockholm Syndrome was dubbed Stockholm Syndrome after Patty Hearst. It might have been before your day, Ken.
Who's Patty Hearst?
Patty
Never
Hearst.
heard of him.
No, Patricia Hearst in the States. She was one of the Hearst dynasty's children. She was kidnapped from UC Berkeley by a sort of terrorist organization, and within 3 weeks she was robbing banks and had joined the organization because she aligned with them. And it is proposed that when one is in fear, abject fear for one's own life, you actually do begin to align with your abductor. And so because children are so much more malleable, it's so much easier for them, based on their fear and being out of the comfort of their known homes and social groups, to suffer from Stockholm Syndrome.
So in parental alienation terms, then an application of Stockholm syndrome might be where a child is so accustomed to being with an alienating parent that they actually cling on to it, that scenario, even though it may not be the best one, and they might alienate the other parent despite the fact that that parent has done nothing wrong. Is that?
That's absolutely correct. Yes.
Right. The second thing that you mentioned, Caroline, was you said that people should always write a diary and every little detail of things that happen, which of course is very important. One of the things you mentioned there was that they should always print out texts. Now, that was something that somebody before was on to us about. You know, you can't print a text, your phone doesn't connect to a printer. So the solution that our IT guys came up with was that what you do is you just take a screen grab of the text on your phone or the series of texts, and then you can email the screen grab to yourself so that it's then on a computer, which can, once it can be printed or something. That's just a handy little tip that we came up with. Article 15, I got that right, 15 or 13?
13.
The abducted child objects, and then there's no order. I mean, that really is very problematic, isn't it? In circumstances where we know the child to be parentally alienated and therefore coercively controlled, as you say, coached.
Yeah. Yeah.
Well, you know, how in the name of goodness is any half decent barrister not going to be able to convince a judge that the child objects?
You know, it's a difficult one because, of course, and I think I mentioned this last time, when you have a child who's obviously terrified, has obviously been coached and is giving evidence, you as the opposing barrister don't really want to go in and say, well, you're lying, aren't you? I mean, they're traumatized enough. It's just an incredibly difficult situation. So really the better course of action is to say to the judge, look, judge, you've got the witness statement in front of you. You can see that the child is simply repeating every single thing that's said on the witness statement. Perhaps it would be better for the child to be asked questions. The judge can question the child himself or herself, either
wouldn't that be very traumatic for a child to be questioned by a judge?
The way I've seen it done, there's a couple of ways. One, the judge can go into their chambers and dress in lay clothes, and there'll be a couple of people in chambers keeping an eye on things. The other thing I've seen done, which I thought was quite effective, was the child came up to the bench and the judge switched on white noise so that we couldn't hear what was being said. But where they were behind this barrier of white noise, they were having a conversation. But
I personally would have to say that, you know, I think a lot of parents would rather their children never see the inside of a courtroom or, a courthouse or know anything about that kind of thing. And that a lot of psychologists have said to us in the past that such memories are intrinsically bad for any young child.
I agree with you 100%.
Do you think the upside is worth that trauma for the kid?
I don't think it's worth the trauma for the kid because it's never we talk about the voice of the child. A child giving evidence in a Hague hearing, it's not the voice of the child, that's the voice of the abductor. So, and again, I had mentioned that the Hague Convention itself is actually quite small, but then there's I think a 300-page explanatory report by someone called Perez Vera, and they go into all these things in minute detail, but at the end of the day, there are no hard and fast rules. So, at one time the flavor of the month was, well, no child under 11 could give evidence, and now it's 9, and then I've heard it's been 6, and so it's just each country does what they want. But I do think that's something that does really, really need to be looked at, because at the moment, I myself am very, very unhappy about the whole issue around child's objections.
Okay. Well, and rightly so, I think. I thought your 8 behavioral signs of an alienated child were extremely helpful. I hadn't actually come across those before as part of the 5-factor model, about which I would hope at this stage most court-appointed experts would be, with which they'd be familiar. So that will obviously be part of this recording when we go up online, if people would like to spool through it and go and have a look at that. Caroline, on to your next presentation then. And whilst you get that ready, just a reminder about our Christmas tree for alienated children. If you would care to send us the name of your child, we would be very happy to put it up on our parentally alienated Christmas tree and send you a copy of that so that you can vicariously send greetings to an alienated child. You can do that via our website as well at alienated.ie. So Caroline, the next part of your chat this evening is going to be...
I just did want to say a little bit about countries that are not party to the Hague Convention.
Sure.
And I don't have any all singing and all dancing slides. So as you can see, well, if you remember the line, there are many countries, we'll just say Africa, many countries that are not party to the Hague Convention, and actually many countries that are non-compliant, but let me just stick with the ones that are not party to the Hague Convention. So let's just take Malawi, okay? And if children have been taken to Malawi, and let's say a father's taken a child to Malawi and the mother is here, what does she do? Well, I can tell you what she doesn't do. What I would not recommend would be going to an Irish court and getting all sorts of orders that the Irish court is the court of jurisdiction and the habitual residence of the kids is an island and all the rest of it. Because remember, when the kids come back, that's actually the time to decide that. In terms of time and money, one really wants to go to Malawi directly, either to the Minister of Justice or to the courts and file a writ of habeas corpus. And you, being a Latin scholar, will know exactly what that means.
I hope you're not going to say that I obviously know what habeas corpus means. I'm afraid I have not a clue. Something to do with the bodies being around, I expect.
Something about bodies being held where they shouldn't be held. So that really is the way, or the only way, and I know we've used it in India a couple of times, but a writ of habeas corpus would be the way to try and secure the return of the children. The key here is trying to find good and honest lawyers in, say, Malawi. I'm sure there must be some. But I want to give the flip side of this, and to try and illustrate why it's so important to go to the taking country and get stuck in there. Imagine that the kidnapping father in Malawi comes to Ireland with a court document from Malawi and says, no, the Malawi courts have said, this is my child and they have jurisdiction, blah, blah, blah. Well, what are the Irish courts going to do? They're going to laugh them out of court. That's exactly what's going to happen if you bring all these Irish orders over to Malawi. So you do have, possession is 9/10 of the law. So you do actually have to play ball in the country where your child has been taken to. So really a lot of your time and energy is going to be spent assembling your legal team in a foreign country and leave the home country behind for the moment, because it's distracting, it's time consuming, and it's very, very expensive.
Okay, so don't bother going to the Irish courts at all, and just get on a plane or get on the internet and appoint people in the country that you hope your children are safe.
Yeah, and in fact, I should also say, using an abundance of caution, getting on a plane may not be a good idea, because in your absence, as has happened, criminal proceedings could have been filed against you without your knowledge. You may have been tried in absentia. So if you get off the plane in, say, Malawi, you may be arrested for some weird and wonderful things that you had no idea that you'd been convicted of. So that's always the danger. So it's probably better to try and assemble a legal team and create a strategy from a distance, I should say.
So what you're saying there, if I interpret correctly, is that the abducting parent may actually go to court in the country to which they have taken the children and file incorrect allegations against you as the parent who has had your children removed. And because you're not there to defend it, they might even get a judgment against you. And
oh, absolutely. Yeah. Oh no, it happens. Actually, it happens a lot. In fact, in one of my, I don't know why I'm laughing. In one of my cases, I went down with my client to a country that shall remain nameless. And whilst I was there, I was charged with 22 criminal offenses.
Okay.
And over the weekend, these charges had been brought on, I think, a Friday, and in my absence. And I think, I didn't speak the language, but got the impression that I had been found, guilty of violence against women, and, well, I got bored after number 10. I can't even remember what the rest of them were. So yeah, those things do go on.
Yeah, false allegations are an integral part of any parental alienation case, in our experience as well. I've not heard false allegations being made against the barrister, but we've really only got one question that's come in on this, Caroline, and that is, what is Caroline's view on the need for regulation of all court witnesses, including for parental alienation, child abuse, and domestic abuse?
So yes, I'm very pro regulating the experts. In part, well, I suppose I can answer this in several different ways. First of all, I find that several of the reports don't understand parental alienation well enough. And so when I put up the slide about the alienator is charming and is calm and is, they come across extremely well in these reports, and the alienated parent is tearing their hair out, and they don't present very well in the reports. But if the correct questions were being asked, then one could actually weed out the parties and get to the truth of the matter. But the problem is there is no training at the moment. And I do think that PA training must be an integral part of anyone who's involved in this kind of work, be it judges, mediators, social workers, forensic evaluators. It absolutely has to happen. It just has to happen. I've seen reports 20 pages long, and the last line will say, and oh, by the way, I did not find there was any parental alienation.
It's an ongoing issue. I know the United Nations is looking at the whole parental alienation issue at the moment, and one of the things before it is there such a thing as parental alienation?
I don't even know how to answer that.
So
I don't know what more proof they could possibly need than the tens of thousands of cases that are going on every day.
And called parental alienation in the courts around the world, including Ireland, I understand.
Yeah.
So, you mightn't like the name or whatever. And I know a lot of the objections that are out there to parental alienation stem from the fact that people who are genuinely abusing a child are using parental alienation as a defense to say, oh no, it's not true, I'm parentally alienated here. Whereas in fact, they are not being parentally alienated. The other parent is protecting the child from them and their abusive ways. So it's kind of complex, isn't it? But I mean, the only analogy I can draw on it, and please give me your thoughts on this, is that it's kind of like saying, well, you know, there's a murderer who tried to claim he wasn't a murderer because he was only guilty of manslaughter. And because people are using manslaughter as a means to try and get off murder, we're going to say there's no such thing as manslaughter anymore. It seems bizarre, but I must be missing something. Can you shed any light on
it? I can't shed any light on it, but I have been doing a bit of research, and I was trying to find in my practice where every kind of allegation has been, you know, I've come across pretty much everything. I've never ever had an alienated parent have any of those allegations proved. Now, I'm not saying all allegations are spurious, but I'd love to see some research into how many times in a high conflict, and I'll use the word divorce, so high conflict state where parties are falling apart and the children are an issue, but how many of those allegations that are brought are actually proved and sustained? That really would be, I think, a good starting point.
I suppose for something like that, though, you'd need to have no in-camera rule, really, so that the cases could be studied and the research could be done and empirical evidence could be gleaned.
Yeah, so we're stuck in a chicken and egg situation at the moment.
Yeah, it is. And I know that in Ireland, our Minister for Justice here is working hard to try and figure out a way to change it, and has called for a study to be done. And hopefully that will result in some changes to the legislation and the practices around it. I shouldn't have said that we only had one question in, Caroline, because they were obviously being very kind to us and not interrupting us while we were chatting. And since I mentioned that, I can see about 400 now. So let me quickly run through a couple that have been highlighted for me here. Are Section 47s and other means to determine what is best for the child fit for purpose? That's the Section 47, for those that are not familiar with the Irish court system, is basically a psychologist's report on the welfare of the child, its situation, and they tend to make recommendations which typically judges will find themselves unqualified to refute and therefore accept.
Yeah. I think I'll just give you my overall view, speaking to Section 47s and their the partner Section 47s in the different countries that I've worked in. My issue is that judges are busy. It'll be a 10-page report and they will flip to the last paragraph with the recommendations. So fit for purpose, well, again, it goes back to what we were first talking about. I don't really think so, because at the moment, to date, because there is no PA training, the ways that those reports are put together are led by the charming alienators, and things always go terribly favorably. And I think it's very much weighted without the hard questions being asked to really take the time and find out what's underneath, what's going on. So
in essence, I suppose it boils down to the fact that the experts are not themselves regulated and they're not put through any official training. So you don't know whether the Section 47s are appropriate or not.
Well, that's right. And an example would be, well, my daughter doesn't want to see her dad. And daughter doesn't want to see dad. Well, shouldn't the comeback be, why? and when did this happen? Because that's very unnatural, and let's explore this. So that should be a whole, instead of child doesn't want to see dad. I mean, that to me is not, that's the beginning of the report, not just one sentence in the report. I could talk about these reports forever. I know everyone's under time pressure to get them done, but I'm slightly troubled as to their content or their lack of content.
And a total lack of regulation as to what their format should be and what should be in them and how to address them.
Exactly. I think you've just hit the nail on the head. It's the format.
Caroline, do you have to pay to get an audio of your court case? If you're in court one day and you, as a lot of people are, extremely stressed, they have this DAR thing. Is that the correct word? Digital audio recording system in place. Are the litigants allowed to get a copy of that tape?
I have no idea.
Fair enough. I like honesty. Do you know of any alleged parental alienation or enforced parental alienation estrangement cases where no offense was committed?
So when you say no offense, there's no allegations of domestic abuse or drugs or stuff like that, just straightforward alienation, pure and simple.
You'd have to interpret it yourself. It's
Okay.
a viewer's question, so I'm just reading out the ones that Paul selected.
So my answer would be absolutely.
Yeah,
many, maybe half of my cases are just simply, my daughter and I had a great relationship, and then we got divorced, and now I don't see her. Just black and white, no reasons, no nothing, no incident happened. Because sometimes, the allegations don't have to be of a criminal nature. The crime can just be this gaslighting, actually, which we know isn't a crime, but it sort of is. So
another bandied about word there, gaslighting. What's your definition for that?
So gaslighting is making the other person, putting a thought into somebody else's head and making them think it's theirs. So you didn't really have a good time at dad's today, did you? Or just things of that ilk. Or
is it coercive control?
I think there's a good overlap between the two. I wouldn't be able to define them completely. Or I miss you so much when you're over at your dad's, or, well, I'm glad you had a good time because I was here really lonely. Just that kind of messing with kids' heads. And kids' heads are like sponges, and they're very sensitive. So that, to me, borders on criminal behavior. But I think the viewer was probably asking, without the police being called or without charges being filed, have I ever seen parental alienation? Yes, a lot.
And in court, we've had people who tell us of instances where it seems that even when the judge does make orders, on some occasions they are absolutely mandatory and must be adhered to the letter. And on other occasions, for different people, exactly the same order can be considered optional almost. And if these orders are ignored, there doesn't seem to be any comeback. I paraphrase a question which has come in, the words of which are, why is there still evident lack of prosecution and enactment of legislation for those who don't adhere to court orders?
And I had actually done or tried to do some research on that. And again, the statistics or any recent statistics are very, very thin on the ground. The lack of adherence to court orders is prevalent. And the lack of any consequence is also very prevalent, which just encourages one to continue on in that same vein. I don't know why that there are not more contempt orders issued by the bench. Indeed, that is what should happen. And it may be, you know, as we create a proposal for law reform, we really do have to look at that.
Bob Geldof, in his excellent documentary of 2012, I believe, which is up on YouTube, states that the judges will answer to why they don't prosecute with, well, I can't put the mother of the children in jail, or I can't put the father of the children in jail. To which Mr. Geldof's answer is, well, yes, you can, and you have the power, and that's what the legislation tells you to do. And guess what? If that happened once and somebody was sent off to the local jail for 15 minutes to have a cup of tea, but all the neighbors heard about it and the word got around the court system, you might well find that people would be adhering to custody orders and access orders far more than they otherwise do, was the argument, which I suppose, would you agree with that?
I would, and a financial penalty would also make someone think twice about messing around with custodial orders. But the other thing,
that was the only thing that our former Minister for Justice, Alan Shatter, when he brought in the 2015 legislation, said he didn't know why they had taken it out, because financial penalties was one of the punitive measures he suggested for cases of people who deliberately ignored court orders, to give the judges some kind of recourse, which wouldn't be as severe as prison. But the legislators insisted on that being removed. I wonder why that was. Is that jurisprudence? Is that what we call it?
I don't know why. You know, another option could be something like, in America, if you get a speeding ticket, you have the option of paying it or spending a weekend at driving school. So, you know, when we talk about options and when we don't have the money to put people in jail or to we'll send them to parenting school for the weekend, have them pay for it, let the independent parties who come in run the parenting courses, so they're more than happy to do it. And it's really quite grim having to sit in a small classroom for 2 whole days of your weekend being taught how to be a decent parent and listen to court orders. I mean, to me, let's have the simple solution.
Is there such a thing as a parenting school?
Well, let's make one.
Okay. We're going to change the world here. A question: how can one prevent relocation and abduction if one suspects it might occur?
So you get the passports of the children held by a third party. Now, in the States, we used to apply for this. The courts would hold the passports. I don't know who the relevant authority is here. A neutral third party, and I'm just throwing out names. I don't know who does it in Ireland, but there will be a commissioner for oaths, that there may be a neutral solicitor who would agree to do it. That certainly would be the first step in preventing any abduction.
Okay. And the Gardaí also, I understand, have a register of and the Department of Foreign Affairs, is it, which parents can put their children if they suspect they might be abducted, such that when they do turn up at a port, that parent will get a call to say, your kid is here and leaving the country. Are you aware of this?
Yes, the alert will go out to all the ports, and it's easier to do it in Ireland than anywhere else, just because we have so few points of exit. So it is actually quite efficacious here to prevent an abduction.
Good to know. Good to know. In the event of a relationship breakdown due to domestic violence and one parent refuses to return the children following access and both parents have guardianship, what rights does the parent who is being refused the children have whilst waiting for a court date, which can often take 6 months? And if you go to the Gardaí, they'll just say, well, it's a civil matter, we can't help. That I suppose is the extent of a rather long-winded question.
Okay,
so I mean,
so the option, Well, no, the option, although it's not perfect, it's still something, is to request supervised access. So that's where there is a third party who is, a chaperone, if you like. And I would
You
highly
need to get into
encourage.
court for that, right?
Sorry?
You'd have to get into court for that.
Well, if the other party is, in theory, everyone's adults and should be able to sort these kinds of things out themselves. But if the other party would agree to a chaperone, if not, yes, you would have to go to court and get an order for that.
And therein lies the rub, because you might be waiting 6 months to get into court. And for those 6
Exactly.
months, the Stockholm syndrome continues. And how long did you say that takes? 3 weeks?
3 weeks, yeah.
Mothers usually have social welfare. Now, I'm not saying these are my words. This is a question that's come in for you. The last one said, as you were refining there, keep up your great work, Caroline. Mothers usually have social welfare and free legal aid. I don't know that that's necessarily true. I think fathers have access to both as well. They can move to any part of Ireland with support from the fathers. They tend to be full-time employed and cannot afford a legal team. When they bring applications to enforce orders, Irish judges tend to issue Isaac wonder orders and costs against the father. Can you tell us what they are?
So is the gist of the question that mother has legal aid, father has moved away and is working, and then an order for contempt is made, but father bears the cost of it? Did I get that right?
That's my understanding, yes.
Right. Well, I mean, I think costs should go in the cause. In other words, costs should wait till the end of all matters are decided. But that is the difficulty. If you're not legally aided, you can, not always, but you can get penalized, if you like, with the other side's costs. But if the other side's at fault, I'm not quite sure why you would be picking up the other side's costs. That doesn't make any sense to me.
Yeah. Okay. Well, I'll move on. Another one, in terms of a child who has been parental alienation and somehow or other the victimized parent has gotten the child back. There's a question as to, do we have resources to deprogram a brainwashed child?
Well, yes, there are. And in fact, that's a good term. I try and stay away from it, but that's really what it is. They're called reunification programs. I don't know if we have any in Ireland yet, but there certainly are therapies available to families to enable a child to re-enter the family without fear, having obviously been told terrible things about them. So it's very traumatic for everyone, particularly the child, and there is help there available. And I think you might have a couple of things on the ACF website, if I recall, about that.
We do. Sadly, many of the experts in this tend to be overseas, which means that you're looking at great cost. And I know there are psychologists in Ireland trying to train themselves up in this area. Some may be qualified by now. I'm not sure, but if we hear of them, we will of course put them up on our website. What is the biggest pitfall, Caroline, that parents face applying to a different jurisdiction?
Applying to a different jurisdiction overseas?
Presumably, yeah.
Okay. I just didn't think you meant within Ireland. The biggest pitfall, I would say, because I'm actually trying to help a few people do this at the moment, and obviously I'm a bit better placed to do it, is finding a trustworthy lawyer. I've recently come across a lawyer who's taken on a case who is manifestly unqualified to do it. I can't even talk about it. I'm just so appalled. But anyway, that would be the biggest pitfall. So my advice would be to do what I do. I get a short list of about 5 people. I put it out on I do have a lot of networks, and then you just need to phone up these people and ask them. I think I put up a list of questions on your website. I might do another list of questions for abducted children. You've got to ask the questions. How many abduction cases have you done? What's the rate of success? What countries have you worked in? Don't ever go to someone whose first case it is. That, we all had to have our first case, but that to me would be the biggest pitfall, particularly if you're going into a country where you don't speak the language. So as I mentioned last time, get a translator on board and then try and find, I might do a little piece about, I did a little piece about finding Polish lawyers, but how you can find lawyers and the groups. I'm just writing that down. Because there are lots of, yeah, there are, you can do it that way. I'm not sure that would be, I wouldn't rely on that solely. I would go to lots and lots of different kinds of organizations to try and find people, get your short list and interview them, and then from that go forward.
Can you please ask Caroline, will parental alienation be taken seriously and addressed by the courts, given that I am a single father and my daughter lives with her mother? We were never married, so I don't have equal rights. Sounds sad, doesn't it?
It's difficult in Ireland because you do need to have some kind of guardianship rights, which would either be by a joint declaration or whereby the father goes into court and says, I have a right to this child because, or where the father has lived with the mother for 12 months and 3 of those months must have been after the birth of the child. So I don't know if he qualifies under any of those reasonings. If he watched the last seminar, I did, the slide that I skipped was how to get guardianship rights. And so it lays it all out there.
Okay, great. This is I suppose, an important one that we've already addressed some weeks ago by coincidence, but you might be able to shed some additional light on it. The question is, how are we supposed to find out which country the child has been abducted to? We did a webinar recently on a phone app, which is also available online, I believe, called findmyparent.org. But that's only just starting up now, and it's primarily being used, I think, for children from the Ukraine or parents from the Ukraine who have gotten separated during the war. Do you have any answers or suggestions on that one?
What I used to do was I used to phone airlines, and then I'd phone legal counsel of airlines and demand passenger lists. That ended. That was an easy way to do it. And yeah, they wouldn't let me do that anymore. The other thing I was able to do, which I'm sure now with GDPR you can't do, was to pull people's telephone records to see who they've been phoning. That gives you an idea of where they may have gone. If you have absolutely no clue at all, it would be extremely difficult. I did have one of my very first cases, the child, this is an interesting case, the child was taken from England and the mother was from Bangladesh. The father presumed the child was in Bangladesh or thought maybe the kid went to the States, didn't know. And it was in the days when they put pictures of children on milk cartons. And 2 years later, someone saw this kid's picture on a milk carton, realized he was his son's friend and called the FBI. And that's how we got the child back to England. I don't think we do the milk cartons anymore. You can go up on the, you put your child's picture up on the ICMEC, which is the International Center for Missing and Exploited Children.
Sorry, can you call that one out again, please? I just jot that one down. International
ICMEC, which is the International Center for Missing and Exploited Children. And I think some of the Europol and Interpol, I know the FBI has a whole area dedicated to missing children, but I'm presuming that Interpol and Europol do as well.
And presumably the first port of call in that would be the local police force, the Gardaí in the case of Ireland, who would be able to point you in the direction. Does Ms. Langley think mediation has a part to play in progressing resolution? Does parent execute alienation unknowingly due to insecurity or anger? Well, it's more of a psychologist's question, I suppose, in the second part, but perhaps the first part you might address.
Mediation certainly has a part to play, but again, the mediator has to be educated in parental alienation. In fact, when it was the gentleman who I suggested that he has supervised access with his child until they could get the other gnarly bits sorted out, that would be best, frankly, going through a mediator. My view is that one should always try mediation because you and your partner are bound for at least the next 18 years through this child. If you cannot sit at a table in a room for 2 hours, then there is no hope. So nobody loses in mediation. If it doesn't work, it doesn't work. I've often found it very, very successful because you can start together. If someone is uncomfortable, they go off to a room on their own. The mediator sees them on their own. So we can do this back and forth and together. I like using mediation, and I do think it's extremely productive in these really, really tense matters. The other thing about mediation, it is just the parties. It's just mum and dad. So you get rid of the noise, you get rid of the cheering band, you get rid of the, the not so helpful family members, and it's just the two of you. So I do like it, I must say. I like being a mediator.
Okay, this is a poignant one because we had a couple of calls this week from people who say, my son's school or my daughter's school has refused to meet me for a requested meeting to find out how my son is or my daughter is going, because they say the child has requested that their parent not be allowed to attend the school because they find it very distracting and or upsetting, and the children are the first priority of the school. Therefore, the parent has received letters saying, please do not show up to the school and we will not meet with you to discuss your child in these circumstances. So the question is, how do we educate schools about this family dynamic, and how do you suggest that we can prevent abduction, which is, of course, a form of alienation?
Well, the first thing I would do is look at the school's charter. I find hearing that the school is exercising powers way beyond that which it is given. It is not, I would be surprised if in the school's charter it says that they have that kind of power to make those kind of decisions. I don't think they do. It's a parent's right to have access to the child's school reports, to speak to the teacher. If it is correct that the child is upset with the parent being there, the child doesn't necessarily have to be there. But this cutting off parents from having any part in the child's life is really overstepping the boundaries. So that's a great question.
Yeah, well, the case that I was aware of was where a father didn't have any custody to his children. The mother had been given sole custody rights of the child, which was presumed, I understand, to have been of administrative assistance, and nothing else was supposed to occur. But notwithstanding that, the child having asked the school not to allow the man attend the school except in the presence of the mother was adopted by the school as an appropriate way to behave. I suppose what the first thing that struck me was, well, hang on, this child's probably been put up to saying that to the school, and if they understood the fundamentals of parental alienation, they wouldn't be doing this. But again, that goes back to the question: how do you educate the educators?
Well, we have a lot of people to educate, and certainly it would be interesting when the time is right to, if there were enough cases, to do a judicial review of schools overstepping their boundaries, because certainly there are cases where some parents are kept out of schools, but I don't think it should be a widely used practice at all. I mean, it's just another means of. So now, we've got just not one alienation. Now we've got a gang of alienators, and it can't go on.
All of whom, of course, are coercively controlled and believe they're doing the right thing, and ultimately being manipulated, I suppose.
Yeah.
Caroline, we've gone way over time, and I'm only a quarter of the way through all of the questions that have come in for you. Is there anything specific you'd like to say before we wrap up?
I don't think so. Just thank you to everyone for listening, and Ken, thank you for being a wonderful host. And I hope this has just helped people really focus on their rights and not being afraid to take matters into their own hands as best they can, or even have enough knowledge so that you can ask the right questions of your legal representatives. But we are here to affect change, so I hope this is the start of something wonderful and amazing.
And indeed it is, and thank you for your contribution to it, Caroline. It's very, very gratefully appreciated. So there you have it. We have now got a DIY kit for how to deal with abduction from Ireland and into Ireland. I hope that's been of some great assistance. I found it absolutely fascinating. And thanks again to Caroline Langley for that. This interview will be up on our website in the next couple of days if you've missed it, or if you'd like to look back upon it, along with all of the other webinars that we've done and the resources that we've come across that we believe will be of assistance to parents who are in any way involved in parental alienation, a rather unfortunate and insidious form of child abuse. So there you are, from Kenn Joyce and all of us at Parental Alienation Ireland, aka alienated.ie.